My name is Julian Koo, and I'm a professor of law at Hofstra Law School, and I'm going to moderate this panel panel number 3, Constitutional Prudential Limits on the Treaty Power, Federalism, Delegation, or Some Other Principle. And I want to thank all of you for sticking it out through the day to all the different events that have happened here, and for staying for this panel. I want to promise to do my best to make it worth your time. We have done so by gathering a panel of very distinguished, and more important than distinguished, very interesting scholars who will discuss the legal issues related to international agreements made by the United States. The importance of this topic might be debatable. It's probably not. It's not hard for me to see, as we sit here at the beginning of year 2, of what could be potentially one of the more internationalist U.S. administrations in the past 40 years, and certainly served by one of the most brilliant, but also one of the most, I think, internationalist or transnationalist State Department legal advisors, my old professor Harold Coe. In this sort of combination of folks, could be potentially a lot of activity in the international agreement area for the United States, and certainly within the next during this current administration. Still, this is too large a topic to handle even in the time we've allotted, so we're going to focus our discussion in 2 ways. First, we're going to concentrate on 2 of the most important of the many difficult legal issues arising out of international agreement making by the United States. One will focus on the use of international agreements to delegate power, U.S. government power, to international organizations and institutions. And second, we're going to discuss the effect domestically of international agreements on U.S. constitutional principles of federalism and general state autonomy in the United States. So we'll focus on those 2 issues for the most part. And second, I've asked my panelists to be somewhat forward-looking, to try to offer a little bit of predictive claims about how the doctrines that we'll talk about will evolve, rather than simply the normative claims that we often make in these contexts. But we're going to definitely offer those normative claims as well. So before we go to the panelists, I want to situate our discussion a little bit by providing some background. The United States is party to literally thousands, for all I know, tens of thousands, of international agreements. It's fair to say that the pace of international agreement making is not likely to slow down in the next decade. I believe this reflects the continuing globalization of economic, social, and political activity, which has accelerated since the end of the Cold War. What's more interesting, to me at least, than the number of international agreements is the nature and scope of contemporary international agreements. As we'll discuss today, modern international agreements seek to encourage and indeed require a much deeper political integration and cooperation than in the past. Second, international agreements are no longer just bilateral agreements, but they often are huge, humongous multilateral agreements with hundreds, more than 100 states, which seek to require the member states to comply with a complex set of rules and regulations. And so to give one relatively uncontroversial example, the World Trade Organization has over 100 members, has the authority to determine whether member states like the United States are in compliance with their obligations under the WTO agreements, and to demand that the United States comply with those obligations. The nature of those obligations are hardly obvious from the text of the agreements themselves and requires administration and interpretation by WTO institutions. Now, in recent years, scholars in the United States have identified this process of delegating authority to international institutions as international delegations, and this can encompass any kind of transfer of federal power. We could transfer the power to decide cases under the law. This would be the transfer of judicial power. To administer or execute U.S. law, that would be perhaps the power to execute U.S. law under the Appointments Clause, perhaps, or to make rules, legislative power. And as our panelists will explain, international delegations, or they might disagree, they are at least a potentially important phenomenon, and they're even a real phenomenon. It's not obvious how the U.S. system will respond to this. The first effort by the U.S. Supreme Court in the Medellin versus Texas in 2007 dealt with an ICJ interpretation of a U.S. treaty obligation, which were claimed to be binding on the U.S. Supreme Court. And this is the first effort by the U.S. system to try to deal with these kinds of delegations. The second big trend in international agreements, I'm going to argue, is the broader scope of their subject matter. Modern international agreements seek to regulate a wider set of topics, say more than just diplomatic rights or say peace treaties, etc. Now we have treaties regulating international human rights, private law, including commercial law, family law. If those of you who watched the Today Show could follow the travails of the American father from New Jersey who was trying to get his son back from Brazil, and he invoked his treaty rights through a 10-year or 5-year litigation to do it. It's a classic example. Now we have treaties regulating areas of domestic relations. So I think this means that in the U.S. context, we have treaties now that we could sign or have signed that regulate matters that were traditionally or even constitutionally required to be left to the state governments. And this has created tensions, especially as there's been at least a mild, if not a robust, revival of federalism by the courts and in the public sphere over the past 20 years. But there's been at the same time a strong effort to create and have the U.S. join many of these new, very ambitious international treaty regimes. Now, the Obama administration came into office with a distinctly internationalist orientation, by which I mean a strong commitment to international legal institutions. And the president himself has chaired a meeting of the United Nations Security Council, has instructed the U.S. to rejoin the UN Human Rights Council. He's signed the Convention on Disabilities, and he has pledged to submit or advocate for the completion of human rights treaties like the Convention for the Elimination of Discrimination Against Women, the Convention on the Rights of the Child, and the Law of the Sea Treaty, and among other treaties. And he has also made some noises about closer cooperation with the International Criminal Court. And so I think that, and most importantly, I think, he's appointed sub-cabinet officials of very high stature and international orientation that are likely to advocate for greater use of international legal institutions. Many of you know the State Department legal advisor Harold Koh, the former dean of the Yale Law School, is a well-known legal scholar who, in his work, has advocated the greater integration of international law into the domestic U.S. legal system. Less well-known in this crowd, probably, the State Department's Assistant Secretary for Human Rights, Michael Posner, is the former chief of Human Rights First, which is a non-governmental organization formerly called the Lawyers Committee for Human Rights, which is also famous and has focused its advocacy on the integration and compliance of international legal norms with the U.S. system. So I don't think that, at least even if they necessarily haven't accomplished a lot of the policies, the general orientation of the administration is greater reliance and interest in international institutions and international agreements, perhaps, than prior administrations. And even beyond the current politics of today, I think there's reason to think the trend toward more international agreements requiring more delegations and a further shrinking of state autonomy, given the subject matter of modern international agreements, all of this is likely to continue. So the question for our panelists is how and whether U.S. constitutional norms will affect or accommodate this trend. At least that's one of the questions I'm going to pose to them. So our panel today consists of three very, as I said, distinguished but also interesting scholars who will discuss some of these issues for us. We'll start with John McGinnis, who is a Stanford Clinton professor of law at Northwestern School of Law. And then we'll proceed to David Sloss, who's the a professor of law at Santa Clara University Law School and the director of the Center of Global Law and Policy there. And then finally, we'll hear from Professor Duncan Hollis of the Beasley School of Law at Temple University, who, and all of them, and then I'll offer some comments of my own and questions for them, for each of the panelists after their presentations. So we'll start with Professor McGinnis. Let me just say a couple more words with each panelist. John doesn't really need much of an introduction for this crowd, I think, or actually anywhere in the legal academy. He's a leading scholar and important voice in the fields of constitutional law, foreign relations law, international trade law, international law, and some other areas I don't know myself, but I'm sure he is. His latest article, The Future of International Delegations, was published in 2009 by the Yale Law Journal, and will probably no doubt form of our conversation today. So, John?